Hello, welcome to our webinar. Today we're going to talk about sex, drugs, and human resources in the workplace. We are sponsored today by LandrumHR and by Partington Law Firm. We're going to talk about a variety of topics including sexual harassment, drug-free workplaces, a variety of human resource issues, and we're also going to talk about cybersecurity. Today our first guest is Daniel Harrell, who's a partner with the law firm of Partington here in Pensacola. Daniel, can you take a moment and tell us about your law firm?
Sure. Partington is a full-service firm located, headquartered in Pensacola. We've got 5 offices between Orange Beach, Alabama, and Tallahassee, so we cover the entire panhandle of Florida and the Gulf Coast, including office in Alabama. My particular practice is a litigation practice focused on employment issues and a lot of employment counseling as well.
Okay. And does your law firm handle things other than employment law?
Sure, absolutely. We can handle any form of litigation. We do lawyers that do nothing but transactional work, and we really have a broad set of lawyers that can cover almost any issue for any company.
So you're a full-service law firm?
Absolutely.
Okay. Well, today we're going to focus on employment law issues, and I'd like to start with sexual harassment.
Okay.
It has certainly been on the front page of every newspaper and every magazine, and it seems like every time I turn on a news program, there has been another high-power male who's been accused and sometimes apologizing for inappropriate behavior in the workplace.
Sure.
I would think that one of the keys to preventing this in the workplace is being proactive.
Absolutely.
Can you talk a little first about what sexual harassment is and what an employer might do to spot it and prevent it?
Sure. Well, sexual harassment has a couple of different connotations. One is what I think the public thinks of and what a lot of what we've seen in the media in the last several months. The second kind of specific connotation would be the legal one, which requires certain specific things to have occurred in order for there to be a legal, viable claim for sexual harassment. But an employer really shouldn't make much of a difference between those two, because even if you have an issue with sexual harassment that doesn't rise to the level of a legal problem, it's still going to be a workforce issue.
I agree.
And ultimately, employers need to take the right steps to make sure that they are given the information they need at the right points in time so that they know what is happening and what they can do to stop it. And that really means that ultimately the employers need to put the right safeguards in place through policies, through training, and by making sure that the Human Resources Department is a critical piece of the component when someone believes that they're having trouble with any sort of harassment.
And from a proactive standpoint, I would think that transparency would be key in terms of having a healthy workforce where somebody feels free to come forward and say, hey, this doesn't feel right, whether it's legally sexual harassment or just maybe uncomfortable behavior. There has to be some feeling that employees have where they are free to come forward without fear of retaliation. Absolutely.
What we're seeing in the media now is a big move towards people coming forward and letting the public know or letting other people know what they're experiencing. Mm-hmm. And that's a great opportunity for employers to, at this point in time, look at their policies, look at how issues like this are being handled in their workforce, and make sure that they're doing the right things to protect employees and to provide employees with what they need in order to feel comfortable in coming forth, because an employer is ultimately protected under the law if they do the right things up front, and if when a complaint occurs, they take the right action to make sure that the issues are resolved appropriately. If an employer turns a blind eye to these issues and doesn't do the right things right now to make sure that they have the right policies in place and that their employees know what they're supposed to do, that is really the issue that is going to create scenarios of liability for employers moving forward.
Yeah, so one of the common questions I've heard over the years is, I may be an employee with a complaint, but I want to keep it confidential because it makes me a little uncomfortable to talk about. How does an employer respond to a request for confidentiality?
Well, there's a request for confidentiality is something that's important, but writing into the policies what the expectations should be is really the key way to make sure that employees don't feel like they've made a complaint and then they've been treated poorly because of that. And the best way to do that is to, within certain policies, write in that the company will do everything it can to maintain confidentiality. But as you and I both know through working through these issues, oftentimes to conduct an appropriate investigation, you have to let a number of people know what the situation is. And as much as a company wants to be able to try to maintain absolute confidentiality, it's nearly impossible to do that in a lot of settings. So by putting into the policy and by relaying to an employee up front that we're going to do everything we can to make sure that this issue is maintained in a confidential setup, letting them know that appropriate action needs to be taken in investigation so that the issue can be resolved. The other thing that helps out is letting the employee know that retaliation is something that will never be tolerated within the company. And if something gets out and someone takes a negative action against them, they have a person they can go to. And what I'm telling clients currently is that that person needs to be laid out specifically. If you have a problem, call so-and-so at such and such number, or email so-and-so at such and such address. And if you lay that out for them, they're put in a position where, while you may not be able to ultimately keep it absolutely confidential, you've given them the tools they need, that if they feel like they're being retaliated against, they go to the right person, and that issue can be nipped in the bud.
I agree, especially about the retaliation portion. So tell me, so far we've seen a lot of women come out, but other people are protected under the law as well. It's not just a law to protect women.
That's correct. We have seen over the last 20 years an increasing number of issues with female harassment of females harassing males, males harassing other males. This doesn't just cut across one segment, it cuts across all segments. And there's been a underlying concept of, well, the only ones that really matter are males harassing females. That's the only ones that anybody pays attention to. The law makes there's no difference in the law between the type of harassment. Any sort of harassment on the basis of gender or of a sexual nature is something that should be reported and should be dealt with seriously. And managers, frontline managers, need to be made aware that this isn't just a male-female issue, but it can create issues across lines, and those need to be taken very seriously, because we're seeing more and more of that as the workforce continues to see more openly homosexual people in management positions and more females in positions managing males.
So the law covers or provides protection for the LGBT community as well.
Absolutely. There is right now there's some lack of clarity as to what Title VII protects, but with a sexually hostile work environment, my belief, based off the case law, is that there is protection, and an employer who doesn't recognize that at this stage is running an incredible risk, just based off the plain language of Title VII, the statute.
And the guidance provided by the EEOC, it's very, very clear.
That's correct.
Yeah. So let's switch gears a little bit to medical marijuana. So medical marijuana is a very confusing topic, because there are a lot of states that have recreational use, like California and Colorado. And then there are, I think, 24 states that have medical use allowed by marijuana. And then there are many states that don't allow either. And then there's the federal government. So can you help us piece those various laws together? How do they all play?
I can provide a little bit of guidance, but one thing that I think is important to point out to employers at this stage is that we are on the precipice of this issue. This issue hasn't really evolved to a point where it's very easy or very safe to say, here's exactly how you need to manage certain things moving forward. The critical distinction in my mind is the difference between a number of states and the federal government. Under federal law, marijuana is still illegal, and under the current administration and just earlier this month, Attorney General Sessions seemed to make it very clear that the federal government doesn't intend to change its position on that anytime soon, and probably not during the current administration. So under federal law, marijuana is still illegal, which impacts the way that employers have to address certain issues. The most obvious one is under the ADA, the Americans with Disabilities Act. A lot of employers are currently questioning, well, what do I have to do under the ADA to accommodate an employee when it comes to medical marijuana? And that is one of the questions that we can answer at this stage because of the the status of federal law. And the answer to that is, right now employers don't have to take action under the ADA to make any sort of accommodation, because marijuana is still considered an illegal drug and not a reasonable accommodation under that law. But there are a number of other issues that are raised by the fact that a number of states have recognize medical marijuana and recreational marijuana, and how does an employer who has offices or facilities across a number of states, how do they manage that? And that's where you get into the gray areas of how are we dealing with this issue.
Right, so just so our viewers are clear, the Americans with Disability Act is a federal law,
Yes.
and the federal government has prohibited marijuana use recreationally or medically.
Right.
So that's why it's prohibited there, even though some of the states may allow it.
That's correct. Currently under the ADA and the case law that has developed, and again, this is very much developing at this stage, but under what the case law that's currently developed addressing these issues, it appears that courts are taking the position of because medical marijuana is still prohibited under federal law, it can't be a reasonable accommodation to allow an employee to use the ADA to get past certain things like a mandatory drug test because of that accommodation.
Right. So one of the questions our viewers had was, what do you do if you live in a state that allows medical or recreational marijuana, but you work in a state that doesn't? Does one state trump the other?
Well, and that goes back to drafting policies that allow the employer to make the decisions that they feel comfortable making and that they want to make at this stage. Yeah, I've had a number of employers call and say, well, we recognize we don't have an obligation to do anything with regards to medical marijuana, but we want to address this in a way that's not favorable to the workforce, but gives them the most relief possible. So we want to potentially engage in the interactive process with someone. How do you do that? Well, one of the ways that I've seen employers dealing with this issue is with a zero tolerance drug policy, to draft a provision of that policy that says you only violate that policy if you test positive for a drug that is illegal in the state in which you're tested, which can be read to say if you test positive for marijuana in Florida and you can produce appropriate documentation showing that you have a prescription, that potentially there is some wiggle room as far as the zero tolerance policy. But it really comes down to employers at this stage should be looking at what their current drug policies say, how they want to address this issue. Right now there's nothing being forced upon employers that they have to accommodate this issue, but now is the time to be looking at it from a philosophical perspective of how do we want to deal with this issue, how can we deal with this issue, and the questions are difficult, but it's something that employers should be looking at now and trying to find out what they want to do and how they want to do it. And I think you can, through policies, set up certain scenarios in which perhaps someone with a condition like MS or rheumatoid arthritis or a number of these conditions in which medical marijuana has proven to be somewhat helpful for employees. How do you address that, and do you want to address that at this stage?
So it seems to me that if I own a business and I'm evaluating all of these different options that I have to have zero tolerance and follow the federal law, or have some flexibility under the state law, that really I need some professional assistance drafting that policy, because it probably has other implications, like under the Family and Medical Leave Act, under your state workers' compensation law.
Sure, and that's what we're seeing a lot of, and you know, I know from an HR consulting perspective, from a legal perspective, companies shouldn't be shy about getting advice from their consultants, from their lawyers at this stage. Which is not what do we have to do here. It's here's what we want to do. How do we set ourselves up to do that? And right now, there's currently a framework where there is some choice and there is some self-determination among employers as to what they want to do, how they want to address this issue. Now, as this develops, there may be there may be less of a choice. But right now, employers are wise to get their legal professionals, get their HR consultants involved in order to help them draft a policy or create a scenario in which they're comfortable with how they want to address the issues.
So I think you just hit on a really important point about the evolution of this. This continues to evolve, and what we're saying today may be different in 2 weeks or a month or 6 months. So really, I would think they would need continuous guidance from a professional.
Absolutely, and that's staying on top of this issue as it continues to develop is key. I know Landrum keeps its keeps people it consults with in the loop. We try to keep our clients in the loop. But it's really important for HR professionals, for companies to stay on top of these issues, continue to follow how it evolves, because we're in the first several years of this process. It'll be 5 to 10 years before I think there's really any clarity on exactly how this is going to work, and maintaining being on top of those issues during that time frame is the key to making sure that your company is in the best position possible to not only abide by the law, but avoid liability and help the workforce in the way that you deem appropriate.
Well, and this would be a good time to mention that ClarkPartington.com and LandrumHR.com are both resources that employers can look at for some newsletters and some blogs and some
Absolutely.
articles on medical marijuana, sexual harassment, what kind of policies you want to have for both.
That's right.
So
that's right.
Those are great resources that are free to anybody to look at.
Absolutely.
So let's shift gears. Let's talk about social media.
Sure.
This is an area that we've been talking about for years, and it continues to evolve. It has changed. Some of the rules have stayed the same. Some of them are not intuitive. Some of them are counterintuitive.
Right.
What's the big takeaway for social media right now for employers?
Well, social media, much like medical marijuana, or marijuana generally, it's an issue that continues to evolve as the mediums in which social media is available evolve. It also continues to evolve as we shift from different viewpoints in our government. Obviously, under the Obama administration, there was a number of issues that came out of the National Labor Relations Board to indicate that that employers couldn't monitor social media a certain way. Now we're in a different administration with a different viewpoint, and the National Labor Relations Board has shifted to where we expect a more conservative approach to allowing employers to engage or tell employees what they can and can't do on social media. So it's a continually evolving issue, and it will continue to evolve because as we sit here today, we think of social media as certain things, and 5 to 10 years it may be something totally different. But what should employers do? Employers should look to draft policies that focus on the things that I think everyone can agree on are inappropriate on social media, and that employer must act on if they find out their employees are acting in a certain way.
Like a threat of violence.
Absolutely. Threats of violence under really any philosophy, a threat of violence towards a co-employee, towards a client, just generally is something that I think an employer can look at and with the right policies drafted should be able to take action on. Along the same lines, derogatory comments related to your employer. If someone is putting themselves out as a employee or as a representative of a particular company, the company should have the ability to expect that they won't talk about how the company is not a good company, or
Sure.
how, and this is where it gets, but there's lines where if he talks about the conditions of employment, is that over the line or not? And that's where, again, getting your HR consultants involved with certain issues, getting your legal advice up front is helpful. But the basic thing is employers can have policies, and they should draft policies in a way to try to make clear what they expect employees to do. And ultimately, most employees will follow that. You'll always have your outliers, just like you do in anything else. But if you make clear what you expect of your employees, most employees will follow the policies and try not to create issues.
And the key is the protected concerted activity. If I, as an employee, post something on social media that the parking lot is unsafe, that probably is protected concerted activity because it's...
Currently, yes. Currently under the NLRB's approach of the last administration, any sort of concerted activity talking about conditions of employment, even wages, was the sort of issues that would get you in trouble if you were trying to monitor that or control that. That may change as the board has shifted. That may be something that employers have a little bit more leeway with. We don't know, but as of right now, I would be very careful in dealing with those issues. But if an employee talks about how a specific company produces a specific product and that product is junk and nobody should ever buy it, that's a sort of derogatory comment that I think it's not about the conditions of employment. It's not protected activity. It's something that an employer who has a policy written in the right way should be able to point to that policy and say, you violated this, and this is something that we need to address, not necessarily through termination, but through some sort of disciplinary process.
Right, or at least getting to the bottom of the concern of the employee. Why did
Exactly.
the employee post it? Because there may be something else going on that's helpful for the employer to know.
That's right.
And just to be clear, the National Labor Relations Board, a lot of questions that we get, employers say, well, gosh, we're not unionized. They don't have jurisdiction over us. But that's not correct.
That's not correct. There is the National Labor Relations Board enforces the National Labor Relations Act, which allows employees to unionize, but it also controls other issues related to concerted activity, which is a legal term of art. But all concerted activity really means is the ability of employees to get together and discuss their work conditions and their treatment. And because that is what's controlled by the National Labor Relations Act, not pure union activity, there is a lot of leeway that the National Labor Relations Board has to provide guidance that affects every employer.
So if I have one word that's a takeaway from this whole conversation, it would be policy.
Absolutely. Looking at your policies, looking at your procedures, and making sure that your HR professionals are clear on what the company wants to do and how the company wants to achieve its goals. That's the best way up front to manage issues. I always talk to clients about trying to figure out what your problems are before they ever occur. And a lot of that can be done through looking at your policies on issues that you know are at the forefront. Right now that's sexual harassment, that's medical marijuana, social media, a number of other things, but looking at it at this point in time and making sure that your people know exactly what they're supposed to be doing is the best way to avoid the really tricky issues that may lead to litigation down the road and phone calls to guys like me that you possibly could avoid if you call me up front and ask me how should we be doing this, as opposed to calling me on the back end and asking, did we do this right? I'd rather be able to guide people as to here's how you should be doing it and hopefully avoid the problem than for the problem to arise and trying to help someone get out of an issue when maybe it could have been avoided in the first place.
I agree. Being proactive can really save you a lot of heartache in the long run.
Absolutely.
Yeah. Daniel, thank you for being here. This information has been very, very helpful. Tell me how our viewers can reach out to you if they have questions on their policies.
You can reach out to through our website, clarkpartington.com. My bio is on the website with a phone number. I'm always happy to answer emails or answer phone call and help provide information on these issues or any other employment issues that may arise.
Great. We're going to take a short break and be back in just a moment. Welcome back to our webinar. The next topic we're going to cover is cybersecurity, and we have an expert with us today, David McCullough. David is the Chief Technology Officer with LandrumHR and has extensive experience in the area of cybersecurity. So David, tell us a little bit about your experience in cybersecurity.
I've been in the technology space for over 20 years, serving in both operational and technical functions and responsible for day-to-day management of technology inside of both IT, software, and HR firms.
Well, technology can feel, particularly cybersecurity, can feel like a daunting task for a smaller employer. Target and Equifax were in the news this year, and they're huge employers. Mm-hmm. So what can a smaller employer do to protect themselves in the area of cybersecurity?
I think it's easy for a small to mid-sized company to think, well, this doesn't really apply to me. You see Equifax that had exposed over 140 million personal records last year. You had Target as well. Home Depot in 2016 had an issue. And so it's easy for a company, a small business, to sit back and say, it doesn't apply to me. But I think what people need to realize is that if you have personally identifiable information on your customers or your employees, you're at risk because you're a target. The U.S. economy is run on small to mid-sized businesses. Mm-hmm. The number one employers in the U.S. are small to mid-sized businesses. So they house the information, oftentimes unknowingly expose the information that's most valuable to these that want to come after it.
So when you say personal identifying information, I know there's also personal health information, PII and PHI. What kind of information is that?
Anything that could identify you to someone that doesn't know you. Name, address, phone number, social security number, any health information, any your health background is very, very valuable. I think if you look at, if the small to mid-sized business looks at it and says, I have information that could, if exposed, cause harm to my business or to my employees or customers, then they ought to be taking cybersecurity seriously.
So I'm thinking that would include credit card numbers, socials, dates of birth, addresses, garnishment information. What are the kind of things that might not an employer think about that would be valuable to somebody who's dishonest? So
I think that employers will think about, I don't have anyone's credit card information, so that doesn't apply to me. But let's just think about simply the name, address, and email of all of your employees. That information is sold on the open market if it's exposed. So everybody's gotten an email, right, that they didn't sign up for or didn't know where it came from. That information might have been exposed and then sold on the open market. Let's also think about these folks that are looking for this information to use it in a nefarious way. They need a way to get to you in order for you to click on a link that they want to get inside your network. The way they do that is simply buy your information on the web, your name and your email address.
Right.
And then they can build these emails that we see that look like they came from inside your organization or from a customer, have a link in it that then exposes your network, and then they're in. Once they're in, they're in.
So we talked about internal versus external problems when we were preparing for this. And at the time, I didn't understand the distinction. Can you tell us the distinction between those two and how those two interplay as well?
Sure. So if you think internally, you think about your internal networks and you think about what you can do, even as a small to mid-sized business, to plug the holes that you might have in your infrastructure. So there's hardware solutions that you can employ. There's software solutions, for instance, Symantec, Norton are names that most people know that can help you plug these holes. But what I always like to tell people is there's another side to the issue, and that's the people side to the issue. Most of the time, these hackers are able to get inside your infrastructure just simply by an unwilling participant, your employee, letting them in. So we talked a minute ago about these emails that come in. These are very sophisticated outfits that are trying to get inside your network and steal information. So they will take an email that looks like it came from your customer, and they will change the URL or the address of the email to look like it came from your customer, even though it didn't. They'll know the name of your customer, and they'll use it to get one of your employees to click on a link in an email. Oh, I need some help with this report. Or, hey, can you help me understand this? And it's a link. Once they click that link and they're inside the network and you don't have a way to catch it, that's that internal and external combination of if you don't have the internal infrastructure and you're not working with your clients and your employees to fill those holes, then you're going to be exposed.
So you could have an internal employee who's very honest in doing their job and clicks on a link that they shouldn't. It's a completely inadvertent mistake, and that allows the external bad guy to enter your system.
That's exactly right. In a 2016 survey of companies that were exposed to cyber threats, they found that it took the attacker less than 4 minutes to get inside the network, and it took over 60 days for the customer, for the company, to find out that they were in.
Oh my gosh.
So once they're in, very quickly, they're inside your network, and oftentimes it's too late when you find out.
So one question from one of our viewers is right on point. How often should a company assess their risk?
So I think in an article that I wrote that's on the LandrumHR blog, I broke it down into 5 areas, what you should do in order to mitigate your risk. Really is assess, number one. Assess where you are today. Where are those holes? And you can, there's companies that will do that for you and help you do that. But after you assess, then you plan how to fill those holes, whether it's a hardware, software solution. It involves training for sure. So you assess, you plan, you test the plan that you put together, both internally, hardware solutions, and any training. Then you implement that plan, train your staff, implement the solutions, and then finally, and this really goes to the heart of your question, you reassess, continually reassess. So at minimum, you should take a look at these types of things once a quarter, so 4 times a year. The more you find holes in your infrastructure, the more you increase that assessment. So you might do it once a month, but at minimum, once a quarter.
So David, if I'm an employee and I receive an email and it just doesn't feel right, it doesn't sound right, it doesn't sound like the sender, or they're asking for unusual information, how should I handle that?
Good question. I think it's important for employers to instill in their employees this don't be afraid to ask the question kind of environment. If you receive an email and it sounds a little bit suspicious, or your intuition says, I'm not really sure this is coming from my client, my vendor, our employee, pick up the phone, give them a call, and just validate that they sent the email, that it came from them. You'll quickly know whether or not this was valid. Some employers are concerned that that may be too big of a red flag for their customer, that, oh, wait a minute, somebody's sending an email that looks like me. What we found is most customers, vendors are thankful that you made the call, that you picked up the phone, and you didn't do anything to expose their data to these cyber attackers.
I agree. I would want to know if somebody were doing that on my behalf, or appeared to be doing it for my behalf. But the rule of thumb is never, ever, ever click on the link.
Never click on any link in any email that's not from someone that you know.
So can you give us one key takeaway for protection of your business and cybersecurity and PHI and PII?
I think that most of the small to mid-sized businesses don't know today how exposed they are. They feel like because they've done 1 or 2 things that they are not exposed. They feel like because of the business they're in, they're not at risk.
Right.
The number one encouragement that I would give these employers is to just spend some time and assess your risk. Bring in a qualified IT professional to look at your risk, because the money that you spend there will more than pay for itself should you have a data breach. This is last year, $86 billion industry.
Oh my gosh,
okay?
That's a lot of money.
Ransomware alone, these ransomware is where people think they're going to steal my employee data, but ransomware gets into your system. Attackers get into your network and then they lock your data down. So they don't steal anything, they just lock it down and put a code that you don't have, and then they send you an email and it says, for $2 million, we'll unlock your data and you can have your business back.
They're holding you hostage.
Exactly right. That in 2017, ransomware cost worldwide over $5 billion. So this is a real business. Treat cybersecurity and cyber attacks as a real business. There are people that make their living stealing data and writing programs to infiltrate networks. Yeah. You need to take it seriously as a small business and spend the time, money, and effort to assess where your vulnerabilities are.
And it seems to me that if I'm a small business and I'm taking these proactive efforts and I'm investing in security, that's something I can turn around and use it as a marketing tool for my clients and my vendors, so that they trust my business and they trust it when they give me their personal information.
Absolutely a differentiator oftentimes for businesses, to say we take your information seriously. And this is what we do to protect it. Absolutely can really separate you from others in your industry.
Great. Well, thank you so much. This is really helpful information. I appreciate you sharing it.
Thank you, Amy.
Our final panelist today is Becky Haynes. Becky is the Director of Training and Consulting for LandrumHR, and she does a lot of training around the country on various employment law topics to help employers stay in compliance and to be proactive to have better workplaces. Welcome, Becky.
Thank you.
Tell me a little bit about your experience in training and consulting.
Well, I started my HR career in 1995 when I worked for Landrum Staffing Services, and I enjoyed working with them for several years, and then I went into healthcare administration, specializing in the HR functions for healthcare. I did that for 16 years, and a few years I had the pleasure of coming back to LandrumHR, doing consulting work and training for local businesses.
That's great. So you have an eye on the trends and what employers can expect to see.
I do.
Because you're training on all these various topics.
Right.
So one of the first trends I know that we've discussed is the changing workforce and changing expectations. What can you tell viewers about that?
Well, what we're seeing is that a flexible working environment is a must anymore for our new employees. Whether it be working remotely or just having differing hours. Remote employees have quadrupled in the last decade, and we're seeing that more and more. We expect to see that throughout 2018. It used to be considered career suicide to not be physically present in a work environment. But today, with technology the way it is and video conferencing, it no longer is the case. We are hearing people say that when they're working remotely, they actually get more done during the workday. We are seeing also a flexible work environment for flexible hours. So long gone are the days that you must work 40 hours a week, Monday through Friday, 8 to 5. We are seeing that we have employees that are working less than 40 hours a week, some that are working off hours, some that are working partial time in the office, and some working remotely. And that's really attractive to a lot of generations. We have our baby boomers who are staying in the workforce longer than their parents' generation did. And they want the luxury of doing some things that do come along with retirement. So they want that flexibility. But we also have this new generation that's just come into the workforce, and they have made it really clear that work-life balance is a must for them.
And it seems to me that a remote employee, that allowing remote employees would allow an employer to fish from a bigger pond, as it were. If you allow remote employees, you could be based in Pensacola but have an employee who works in San Antonio, Texas. So you have more employees to choose from to get the best talent.
Absolutely, and a lot of the companies that we work with actually have a core group that works in their corporate office, but then they usually do have a lot of outlying employees in other communities and other states.
Great. So tell me about financial wellness. That is another thing that we've talked about, and I know at Landrum in the years past we've done classes that have been well attended. Why is individual financial wellness an employer's concern?
It's an employer's concern because we have a stressed out employee population right now. Would it surprise you, Amy, that over 3/4 of employees that are full-time are in debt?
That's amazing. And do you mean just a little bit in debt?
No, I mean a lot in debt. 56% of full-time employees state that they're in debt to the point that they feel like they're in over their heads, which means for us as employers that we have stressed out employees. That affects their health. That also affects their productivity, and that means it affects our bottom line.
Right. It probably also affects their morale and what their focus at work is.
Absolutely, absolutely. So we're seeing employers doing something proactive about this. We've seen everything from financial management classes like you talked about to actually doing payroll deduction to pay off debt for employees, restructuring their debt for them. And one very interesting thing that we're seeing a trend on is in recruiting. In recruiting, we are seeing that people are being offered payoffs for their student loan debt. And I read a statistic recently that just shocked me. A bachelor's degree, the average amount of time it takes to pay off a bachelor's degree is now 21 years. So that is staggering. And we have a lot of people that would love to have that debt paid off. And so if you're looking for a new way as an employer to attract somebody, this very well may be it.
In years past, I've heard of that with doctors and other medical professionals, but I've not really heard of it outside of the medical industry for those really high-level medical jobs. Is this a trend that you're seeing outside of a doctor or a dentist?
Right. I think it started there because that's where we saw the really high loan debt originally. But Now it costs about $1,000 per credit hour just to get a bachelor's degree, an undergrad hour, $2,000 if it's master's or above. So this is crippling our workforce, and we want our employees to come to work ready to go, to stay focused on their job, to be productive, and if we want that, then we need to help them alleviate some of these stresses from home.
And one thing an employer can do if they're building in that kind of program is they can do it where if you stay a certain amount of time, you get a prorated amount paid back. That encourages loyalty and longevity with a company.
Absolutely. In fact, I have seen companies actually the percentage goes up a little higher each year so that if it's a 5-year term, we're not necessarily looking at 20% the first year,
Sure.
but they want that longevity. And that's good really for both parties.
It's a win-win.
Absolutely.
Yes. So the other thing I've heard is LMS. And for a long time, I wasn't sure what that referred to, but I kept hearing about LMS and HR. Tell me what that means.
Yes, LMS means Learning Management System. Basically, it's just a software program that tracks training, administers training, documents training. You can run reports off of it. It really is very sophisticated and very easy to use.
So for, Daniel was telling us earlier about sexual harassment training and how that should be done at least annually and how critical it is, especially today, that you show that you've trained your employees on what the policy says, what the anti-retaliation statement says, and how they can report. So how does the LMS system play into something like a sexual harassment training protocol?
Well, I do really enjoy instructor-led training, but sometimes you can't do that on an annual basis. And there are some courses that do need to be handled annually. Sexual harassment is definitely one of those courses. So my recommendation would be to go ahead and do some digital training with that, have that logged into your LMS, and if you do get a third-party claim down the road, you can easily go back to that and pull those records. And you'll be able to show, hey, Jane Doe did the training on this date and this date. She knew who to file a complaint with. She chose not to do that. And so then you might have an affirmative defense as an employer.
And I'm assuming, too, it reduces the amount of actual paper that you have because it probably all feeds paperlessly into your records retention.
Right. So in the past, what we've had to do is we've had to collect all the sign-in sheets and make sure they go into the personnel files. We've had to collect quizzes to make sure they go into the proper personnel files. We don't have to do that anymore. Now it literally is, they do the quiz online, it immediately goes into their file, and no third parties had to touch it.
And there's no faking those quizzes. Somebody has to answer the questions.
Exactly.
So the employer knows.
Right, and it also shows proof to a third party in the future that not only did we give this training, but there was a good level of understanding.
Right, like a jury, for example.
Exactly.
Where we don't want to be, but if you are, it would be a huge benefit to an employer.
Absolutely.
Yeah. So you talked about the flexible work environments and the bonuses that you just referred to. What are some other new ways to recruit?
Well, when we went to school and then went and graduated and got a job, what did we do? We opened up the Sunday or Wednesday ad, we circled the jobs we were interested in, and we made a phone call. That doesn't happen anymore.
Right.
So we have to go where the applicants are. And honestly, people are living on social media. So whether it be LinkedIn, Twitter, or Facebook, that's where we need to go. The beautiful thing about this, though, is that we can search after that passive job seeker. So that individual that, they're happy where they're at. They're not really looking. But should another opportunity come along, they might be interested. Those are the people we need to go after. And right now we have a 3.6% unemployment rate, which is extremely low. It's dropped 4 points in 4 years.
In the state of Florida.
Right, in the state of Florida. So the problem with that is that you may be looking for someone who's not currently looking for a job.
Right.
And so if your employee is coming to you and saying, hey, listen, I wasn't really looking for a job, this opportunity just came my way, believe them. So this is another reason why, as employers, we have to treat our employees well, because you never know who's going to fish in that pond.
And I think those might be the best employees because they're happy where they are, they're productive where they are, they're not looking to leave.
Right.
And so it speaks to their credibility and credentials in their current employment.
Exactly.
Yeah. So are there any other HR trends that you see that you'd like to share?
One thing we've heard a lot about in the past year that we're going to continue to see in 2018 is Fortune 500 companies that are doing away with their annual evaluations. And at first blush, that sounds horrible. What? We're not evaluating our staff? But when you look at what they're replacing it with, They're replacing it with continuous feedback. And so that means that on a weekly, monthly, or possibly quarterly basis, they have more touch points with their staff. And so they're helping them navigate their annual goals a little bit better. Instead of annual goals being pushed off to the last 2 months before someone's evaluation, they're actually working it and working it hard throughout the year. So far, this is kind of a new thing, but we have seen companies who've employed this are actually seeing their annual goals reached earlier in the year.
I believe that because if you think about running a marathon, the idea of running a marathon is daunting.
Right.
The idea of learning to run 1 mile is not. So if you can set those short goals, you're eventually going to hit that marathon point, but you're going to
Right.
do it in 26 little increments.
Right, exactly. And from an employee relations perspective, this is also excellent because if there is any corrective feedback that needs to happen, it can happen immediately and hopefully nip those things in the bud.
And I think that's one question we often get is from the supervisor who's not comfortable with critical feedback. What advice would you give to that person in keeping with these short goals rather than waiting 12 months to reach a goal?
I would say it's much easier to do it in its infancy stage. It's much easier to say, hey, Amy, by the way, I noticed this today. Let's try to think about doing something differently. Rather than, hey, Amy, over the last 10 or 12 months, I've seen you do the same thing over and over again, and we need to address it. It's much easier for you as a supervisor to make these little small statements and get people back on track rather than to wait 6 months to a year. And then it's like it becomes this big thing.
Right, I agree.
Right.
I mean, if you're doing an annual evaluation in December and you say last February you were late 3 times,
Right.
that has no impact.
No, and it almost feels like you were sucker punched if you're the employee. And you
Right.
don't want your employees to feel that way. You want your employees to know that you're on their side, that you're trying to make them successful, that you're their cheerleader, but you're just trying to get them on the right path.
I think that's really, really helpful. I think it requires a lot of proactiveness from the supervisors, a lot of buy-in from the higher level employers. But after you do that, I
Right.
think you're going to get a better workforce who understands what their goals are and how to reach them,
Right, and I think a lot more efficiency too.
and a lot more fairness.
Yeah.
I think that's critical.
Yeah.
Becky, thank you for sharing all that information today. I think that'll be really, really helpful. If a viewer wants to learn a little more or go a little more in depth, where can they go?
Well, our HR professionals are always pushing things out to our social media platforms, so they can go to Twitter, LinkedIn, or Facebook and find us there.
Great, thank you.
You're welcome.
So thank you for joining us. Today we have heard from our experts in the area of employment law, in cybersecurity, and in human resources. I think the takeaway today is that as employers we have to be agile and we have to be open to change. If you'd like to learn a little more, you can look at either of our websites, clarkpartington.com or LandrumHR.com, where there's a lot of resources. Thank you so much for joining us.